Good morning, ladies and gentlemen. I hope you are slightly warmed up now after having your tea or coffee. The theme of our session is the impact of emerging technologies on the litigation process. I have got two brilliant speakers who will make their presentation, and I have been asked by the organizer to moderate the session. Let me introduce myself. The way we are planning to go, I'll introduce myself. I will then request my co-panelist to introduce themselves. And then I will introduce the subject. And then I will ask the panelists to make their presentation. And at the end, we will have Q&A, depending on the enthusiasm and the energy that you have after an hour or so. I am Abhijit Mukhopadhyay. I am the President, Legal and General Counsel for Hinduja Group. Our group is a fairly large group, 100 years old, 90,000 people in more than 100 countries, doing a business in 10 business verticals. Global turnover is $25 billion. And I am the General Counsel, President, Legal and Company Secretary for the group. Before getting into introducing the topic, I think it will be better if my co-panelists themselves introduce themselves, and then we can take on from there. I have got two co-panelists. One is Hugh Lowe. He is the Director and Lead Analyst at Counsel Inc. in UK. And Cara McGovern Landry, Global Head of Onshore Managed Review at Integrion of USA. Over to you, Hugh, for your introduction, please.
Thank you very much. Good morning still. Yes, my name is Hugh Logue. I'm the lead analyst and director at Counsel. Counsel is a research and advisory firm. We're headquartered in California, but we have offices around the world. My remit is to advise on legal technology and legal publishing, so I advise law firms and in-house legal departments. I also advise some of my clients are legal publishers and software companies. So my intention today is to speak about automated legal services, which is a topic that I wrote a report on a few months ago, and I'm also writing a book on for the American Bar Association.
Cara, please.
Is that on? Is that on? Okay.
Sorry.
Stop touching it. Good morning, everyone. My name is Cara Landry. I use the McGovern just professionally. I am the head of onshore managed review for Integrion. I'm also an e-discovery consultant, e-disclosure consultant. Integrion is a LPO, a legal process outsourcer. We are based here in the UK. I split my time between New York and the EU with the data privacy and data protection rules and regulations. I spend a lot of time outside of the UK. And what I oversee is all of the attorneys who work in my group, who work with outside counsel, who work with corporations in-house, to go through the litigation cycle in what we like to say is smarter and more cost-effective ways. So what I'm going to focus on today is two things. I'm going to focus on how technology is affecting the way that we work every day from a litigation standpoint, from the process itself. And then I'm also just at the end going to talk a little bit about new and emerging technologies and the impact they're having just in the legal landscape and how that's impacting litigation.
Thank you both. As I said, ours is a big group, but if you ask me how many litigations are currently going on, or even how many arbitrations you are going on, I don't think the numbers are too many. Very minimum numbers. The reason being that every litigation, every arbitration is costly in terms of time, management, money, and finally, even if you win, you lose the customers or your partners. So that's why, from the corporate perspective, much to the dismay of the external legal counsels, I will say that we always try to see that the litigation does not happen. But that is one part of the story. The other part of the story is that why we are so worried about litigation, where either we are sued or we sued somebody. It is because of the processes that goes with the litigation. And that is something we are going to deliberate today, how really technology can help in managing the processes well. In a litigation arbitration, there are basically three players. We, the company, namely the clients, external counsel, that is another C, and final C in the dot is a court. Unless and until there is a complete harmony between the three, it is very difficult to get a proper judgment on time. I emphasize on time. Let's give you some example. In India, there are 20 million cases pending in different courts. Yes, you have heard the numbers right. 20 million cases pending in different courts. One of the main reasons why these cases are pending because of poor management of the processes. That process starts from filing an application. It goes up to the level of delivery of judgment. It is not possible for the judiciary to keep pace with the numbers of litigations. And like any other country, India was also quite unreceptive to the idea of remodeling the judiciary, energize them through technology, empowering them through technology. It all started in 10 years back in India when the computerization started taking effects. And after 10 years, I was just reading a research paper. I found that there are 15,000 courts in India today where the technology are being used. And those courts are right from the district level up to the level of the Supreme Court. What kind of technology are being used, which I will come in a minute. Yesterday I was doing some research on some of the other countries where the courts are using the technology. I was reading a report of 2008, the impact of technology or the use of technology in a couple of countries like United Kingdom, Israel, United States, Singapore. And I find that 8 years back when the report was prepared, the technology just started emerging in the courtroom. We all know this concept that justice delayed is justice denied, but somehow or other my experience in handling litigations all over the world as a part of my own portfolio, I find that judiciary is quite slow in accepting technology, whatever may be the reasons for that. The way technology has progressed in the last 10-15 years, which is touching everybody's life, the same way judiciary has not responded, because ultimately the government is not the owner of the courtroom. It is finally the court who decide their own fate. So you cannot do much without touching them. I just want to give you one small example how technology has progressed in our own life and where the judiciary is. I was talking to my colleague Hugh during the tea session, and I was telling him, yesterday I had a business discussions with a group coming from Silicon Valley, and they claim to have invented the smallest chips. And in the morning I was listening about cybersecurity and all, that will help them really to address the problem of cybersecurity. And suddenly the owner, he got a beep. And then when I asked him that what is the problem, he said that, look, I have got a band here with a microchip. My heartbeat, my blood pressure, my functioning of the brain, my functioning of the heart, all are being monitored from Silicon Valley by my own team. Again, they are invented technology. And they just alerted me that slightly there is a problem, but nothing to worry about it. You carry on with your discussions, and we are monitoring. If there is any major concern, we'll let you know, because the gentleman himself was around 75, 76 years old. So I was thinking, oh my God, that's the technology that we are in, and what I'm going to talk about tomorrow within 24 hours, when I will say most of the courtrooms in the world, let's not talk about some 7, 8, 9, 10 countries, they don't even have any kind of technology available. I will say that things are changing in the last 10 years. Today, more and more we are seeing introduction of technology in the courtroom. And what kind of technologies we are seeing, not necessarily in the same order. We are seeing e-filing of the applications before the court. In a large country like India, I think it has already been done. You can e-file anywhere from district court up to the level of the Supreme Court. That's a big achievement, and that's a big problem for us, that every time you have to prepare and you have to file, you have to go to the court registry, and then ultimately, in many cases, manipulation takes place. When I say that it's very urgent and the case should come in the next 2 to 3 days, it can be manipulated at the court registry level. Today, it is not possible. Another area where we are seeing, not necessarily in a particular order, video conferencing is being allowed. Today, we are seeing that document camera are being used in the court. We are seeing e-discovery, which has become a part and parcel of our daily life. Conference call are being permitted in the court, which was unheard of. So like that, there is electronic display board. Today, if you want to monitor your cases, you can easily find out through the technology. Where is your case? Today, cause lists are being produced through the technology. So there is no way I can manipulate in a country in an unethical way. In USA, there is a lot of advancement in terms of technology. I have gone through the report, the kind of technology that they have brought in the courtroom and how it was in 2008, 2009. But then definitely we have got the experts Cara available here. So I will assume that she will, she will speak on that. So the bottom line in today's discussion is that technology, how it is impacting the litigation. And when I say litigation, as I said, there are 3 C's, 3 players in it. One is a client, the other one is a counsel, and the third one is a court. Normally, we are more busy attacking the court, but the law firms are also changing. A lot of technology is being used in the law firm. Whenever there is a big project that is going on, for example, in one big project in our group where thousands of documents are being created in the last 18 months, there is a deal room available in the web. So therefore, you can go to the deal room and find out based on your access what kind of documents are available in the deal room. So law firms are using their technology. I think we as clients, we are slightly behind because as I said that we don't like litigation. So therefore, when you talk about e-discovery, you keep your emails intact, and in the morning you are talking about somebody abusing the others and making all kinds of comments, and email is available. So we are not really very particular about that, maybe because always it is a business concern. So therefore we don't, when we do business, we never realize that it may haunt us one day because the other party may take us to the court. Last point I will make, I still remember 15, 16 years back when courts, they never used to accept even certified photocopy. They say we want to see the original. And today, everything is scanned and it is an admissible document in the court in most parts of the world. That clearly shows how we have shifted in the last 10 years. 2 important points. One is the kind of technology that the courts will adopt will depend upon the kind of budget allocation being made by the government. At the end of the day, it is not for the court to computerize and to create all kinds of technological advancements. It depends on the government. And if the country is as large as India, then it becomes slow. Second point is that when we talk of technological advance, we only keep in mind 10 countries, 15 countries, 20 countries. But as a business group, we operate in more than 100 countries. And in most of the countries, other than highly developed and advanced countries, the technological advancement in the courtroom is really archaic, prehistoric, and we have to depend on more or less on the paper technology. So with that I will stop. This is the subject that we are going to discuss today. I have requested our speakers, both the speakers, to speak for 15 minutes each. After that, I'm sure that there will be questions which you will be able to answer. Hugh, please.